Welcome to this evening's event. My name is Brendan O'Reilly. I'm the president of the Press Club of Long Island. Tonight's event is Photo and Video Usage Rights, what photographers, editors, and publishers must know. We decided to have this event because a lot of people who work in print publishing, or they work in broadcasting, or even on podcasts, they have a lot of questions about when they could use other people's photos, or whether they could use clips from other people's videos that they found on social media, or maybe they've even been submitted and maybe those publishers have actually been told that they have permission when in reality they do not, because they didn't get that permission directly from the content creator. So we have a great panel tonight featuring two attorneys, two experienced photojournalists. Our moderator tonight is Diana De Rosa. She is an equine journalist who has attended 9 Olympic Games. She's also the secretary of the Press Club of Long Island, and she is a photographer herself. Diana, please take it away.
Yes, I'm definitely a longtime photographer, and I'm going to kick this off right away because we want to make sure we fit everything in. So the first person I'm going to ask a question of is Jesse Feitel, and he is a lawyer in the media group at Davis, Wright, Tremaine, where he counsels media and entertainment companies. And Jesse, the question is, am I allowed to use photos from social media or Wikipedia? For instance, if I put my photos on Instagram, does that mean anyone can use them? In a breaking news situation, is it acceptable to use a victim or criminal's selfie from social media?
Thank you, Diana, and thanks everyone for being here. So there are a couple of questions there. You'll see many of my answers tonight will sort of fall on the "it depends" spectrum. So the answer to all of those questions are sort of "it depends." Let me take the first question: am I allowed to use photos from social media or Wikipedia? So you should assume that if a photo is sort of on social media or on Wikipedia, that someone owns that photo. May not necessarily be registered. Someone can go ahead and register the photo afterwards, but in most instances, you should assume that the photo is owned or could be owned by someone, and that it's not necessarily free to be used. But there are a number of factors that could weigh in favor of using it, depending on the context in which you're proposing to use it. If you are, say you're doing an article about a celebrity and you're just sort of describing who the celebrity is and you want to find a photo of that celebrity, using a photo that you found on social media or Wikipedia could be quite risky, because you're using that photo without permission and you're sort of using it to illustrate the person that you're depicting in the article. In sort of lawyer terms, there's an idea called fair use, which I'm sure everybody's familiar with. In broad strokes, it sort of stands for the proposition that if there are certain elements that support your use of the photo, you may be able to use it without permission from the copyright owner. I won't go through the factors. I don't want to get too far into the weeds for law, but one of the elements asks the sort of the purpose for which you're using the photo. And the key point to keep in mind is that you should be using it for a different purpose than the original photo was used for. So if the photo was put up on social media and it's a photo of Brad Pitt, and you're using it in your article, which is just sort of, here's a photo of Brad Pitt, that particular factor would count against you, and you would have a less strong fair use argument. On the other hand, if you're using, if let's say there's a photo of Brad Pitt on social media, I don't know, fighting someone, making that up, and your article is, lots of people are talking about Brad Pitt fighting this person on the street, there you'd have a better, you'd have a stronger fair use argument, because you're not using the photo to just sort of show Brad Pitt. You're using it to help illustrate the debate that's going on social media about Brad Pitt with this photographer. So that's one example. There are other factors that are relevant, but I think the takeaway point is that you should not feel as though you can go onto social media and take photos. There are also varying degrees of practical risk. Was the photo posted with a watermark, suggesting that a professional photographer took the photo, or that it may be registered already, or that the person who you're taking the photograph from might notice it and be upset that you've taken the photograph? or is this a photo that that's been used by other outlets repeatedly? That may not necessarily save you from a claim or from a lawsuit, but it may reduce the practical risk of a lawsuit. Diana asked a really excellent question, which is, can anybody use a photo sort of in a breaking news situation? So the example of a criminal is on the run and they take a selfie of themselves. There you'd have a stronger fair use argument. There is not, the law doesn't say just because something's really newsworthy or really sort of in the news that you can use it, but there are sort of from a policy perspective and depending on sort of the nature of the photograph, if it's important to illustrate the selfie to sort of illustrate, and you're commenting in the article about the photo itself, and your article would have less intellectual heft if you did not include the photo and you're commenting on it in the article, you would have a pretty strong fair use argument. So the bottom line is you shouldn't feel free to take the photo, but there are varying degrees of risk to consider if you choose to do so.
Well, thank you, Jesse, for that great response to a multi-level question there. So Christina Daly is going to be next, and she was the photo editor and lead photographer at the Herald since 2009, and now just started as staff photographer for the Dover Group. So Christina, your question is, what is the difference between using someone's photo for personal, editorial, or commercial use?
So hello, everyone. The main difference between the three is how the photos will be used. So I'm going to give a quick overview of each of them. Personal use is not for commercial or resale or for publication. You could print it on a canvas or mug to hang it in your house, but you don't own the rights to the photos. So you could print out 10 copies of the picture to hang in your home, but you couldn't sell any of those prints. So it's just for your own personal use, nothing commercial or monetary. Editorial is usually more of a photographic story, a photo essay, news content, could be used for educational purposes or the public good. It's usually more creative, not staged, more candid photos, and something that's going to print in a magazine or a newspaper. So editorial photos aren't used to sell or promote a business or a service. The pictures aren't altered in Photoshop. You're not changing the look of the image. Commercial is more for ad campaigns. Those photos could be used over and over for years as opposed to using them once in an editorial context. They're used on billboards, brochures, TVs, social media. It doesn't usually tell a story like an editorial photo would. And commercial photos, we usually need a model release or a property release for art or a building if you're going to use them in any sort of way. Editorial photos don't need those releases. So for our purposes, we're mostly using the editorial styles of photos. So they're going to be printed in newspapers, magazines, and you don't really need licensing for that because they're being used in a news context.
Okay, Chrissy, thank you very much for that answer. And Craig Sanders, you are next. And Craig is the founding partner of the Sanders Law Group in Garden City and a senior trial attorney. So Craig, what constitutes fair use of a photo or video?
Thank you. Fair use is by far and away the most complicated part of the entire body of copyright law that we have today, because it is, in fact, the only defense to a copyright infringement case. It's almost always raised in some context by a defendant to one, and we're called upon routinely to try to figure out, does that defense have any validity? To further complicate this is the fact that the analysis itself is a four-part subjective test, and each of those parts has subparts. So you could ask this question of 5 different judges, 5 different jurors, 5 different attorneys on the same fact pattern and probably get 10 different opinions. But to walk you through it, the first part of the test asks the question of whether or not the defendant's use of the work was transformative. And what is meant by that is that in using the picture, or in this case, the defendant adds something new, some creative aspect that was not part of the original work, and therefore they made something new out of it. Part of that discussion is going to turn on how is it being used? Is it being used in a commercial context? Is it part of a news reporting, which is oftentimes argued by news agencies that anything that they do is fair use? Or is it for educational and not-for-profit purposes? The classic example of a transformative work would be a parody. Now, that doesn't mean that every parody is fair use, and it doesn't mean that something that's satirical is necessarily paradoxical and gets credit for being transformative, but that's the first part. The next two factors are the nature of the work itself, the original work, and the amount of it that was used. These have been pretty much discounted to zero these days, so we could skip over those. The last factor, which is typically considered the most important factor, is what if we let everyone do it? What if we let whatever this infringing use is be done by everybody? What effect would that have on the marketplace for the copyright author? Would there be any marketplace left at all? And since the Copyright Act is by its design supposed to encourage authorship of works and protect the author who created that work from other people using it without their permission, this is the most important factor, and also sometimes the most difficult to analyze because it takes into account the uniqueness of how the defendant or the infringer used the work itself. We could spend, and we do as a group, we have a number of attorneys that work with us, countless hours going over examples. It's actually interesting for all of us involved because it's so bound to the unique facts of each specific usage. And if you look at it critically, and if you take the factors and, you know, this one's for the defendant, this one's for the plaintiff, you go through them one at a time, you reach a conclusion as to whether or not it was fair or not fair.
Well, yes, that is definitely, you know, one of the ones that comes up a lot, fair use. So Wasim Ahmad is next, and he is a journalism professor at Quinnipiac University, who has previously worked as a web editor, multimedia journalist, and newspaper reporter. And Wasim, your question is, what about using the words photo, courtesy of those deadly words, when using a photo?
Well, I think you just answered the question right there with those deadly words, because a lot of people think that if you just put it there that, you know, you got a credit and that should be good enough to cover you. And the fact is it doesn't. You still use the work and you still infringed on that person's copyright of that work. And so just putting those words there don't mean anything unless you actually have the documentation, you know, be it emails or written or otherwise, that show that you have the permission from the person who holds copyright for that photo to use that work. The other thing too is that, I mean, I've had that happen to me, and when that happens to me, I send a strongly worded letter with an invoice to the publication that did the infringing, that didn't ask me and use the photo and thought that was okay. There have been publications that respond promptly, apologize, and, you know, pay that invoice, which is usually what I would charge for a day rate. And then there are ones that don't argue, that don't, and then that gets a little ugly. You know, one of the things that definitely you should watch out for, I've seen people use photo courtesy of Flickr, photo courtesy of Google Photos, photo courtesy of that. And that's just, at that point, you know, Google Photos is not a photographer, Flickr is not a photographer. And so that's definitely not going to cover you if that's what you're doing. So in short, those words cover you not at all unless you actually have the documentation to prove that you have the permission to use that photo.
Well, thank you very much, Wasim. And I think it's really important for us to view this from both the photographer's perspective and the person taking the photo. So, you know, as a photographer, we look at it one way, and as somebody using the photo, they just want to be able to use the photo. So it's a good way to look at it. So I'm going to go to Jessie Pytel next. Do I have the right to use the photo just because I'm in the photo?
This is also I don't know if there are any easy answers, but I think this one is fairly straightforward. And the answer is almost certainly no. The copyright interest in the particular photo is typically in the person who's taken the photo. And to be clear, if I am not a professional photographer, I am thrilled to be on this call with lots of talented photographers. But even if I, use my phone and take a photo at a concert or something, I could register that photograph and sue, if someone infringed on it. But just because I'm in the photograph, the copyright interest lies with the person who took the photograph, and the law is sort of focuses on who is the one who is responsible for sort of the creative input for the particular work. So in a photo, that's typically the photographer who's arranging the elements of the photograph to create the creative work that is at issue in the copyright. So unfortunately, if you're depicted in the photograph, but you didn't play any role in sort of organizing it or taking the photograph, then you're just a subject in a nice photograph, and that's all.
Well, thank you very much. Now, Christina Daly, you're next. How do you verify that you have the right to use a submitted image before publishing it?
So normally the first thing I would do, of course, is ask the person who submitted the photo either where they got it from or if they took it themselves. If it was given to them by someone else, I'll ask them if that person gave them the permission to use it. I'll also check the metadata to see if there's any copyright information embedded into the file. If we aren't able to get in touch with the person who submitted it and it's on deadline and a photo we really need, in the past, I've also tried doing a reverse image search on Google to see if it was used anywhere else with any other copyright information. That especially helps, at least in my experience, when we were using politicians' headshots or headshots of local leaders. They would send us a photo, and when I did a reverse image search, it would come up as being taken by another publication. So I knew they didn't have the rights to use it, and we would ask them for a different photo. Now, when it comes to images like from Wikimedia Commons or Creative Commons license, which sometimes will get submitted, sometimes they'll use them for a stock image. I always tell them to make sure they check the attribution on the image, if it has the Creative Commons license for sure and what they can use it for, and also to make sure they attribute the photo correctly to whoever owns that photo. So if it's submitted to us by someone and they give us the name of the photographer, we'll credit that person. Other times we'll credit the person who submitted the photo if it's something they took themselves or through an organization.
Great. Thank you very much for that. And Craig, you're next. What recourse does a photographer have when their work is published without permission?
Okay, well, this is really going to group into three different possibilities. One is that you send a cease and desist letter. That's a typical cautionary letter asking the infringer to take the work down. Some of them do include demands for payment. There's not that much success as far as the demand for payment aspect, but usually you'll get compliance and the work will be taken down. I'm going to spend a couple of minutes on a new one, which is the Copyright Claims Board, or now it's being called, the Small Claims of Copyright. This is a new avenue that individual photographers can pursue without a lawyer. It allows you to bring a claim for up to $30,000. The problem here is that the defendant's participation in this small claims court is completely voluntary. They have to agree to allow themselves to be sued in that court. If they say no, then that's not available to you. So if they do say yes, it's supposed to be streamlined, it's supposed to be quick. It's a 3-judge panel. The judges are not judges. They're 3 people that were appointed by the Library of Congress, probably lawyers, but it's not clear whether or not they have to be lawyers. And they have a support staff. And we don't know exactly how this is all going to turn out. It's very new. I myself have not been there yet. I have my suspicions it's not going to be a particularly great forum for photographers, because the voluntary nature means that the defendants are only going to go there if they do well. If they start getting hit badly with large awards, they'll stop going. So by the nature of the beast, my opinion is that this is going to be a very favorable forum for infringers and not so much for rights holders. And then the last one is that you can file a case in federal court. I would recommend, if you are going to go that route, that you get counsel. My office takes those cases on a contingency basis, so it's not that there's any cost to you for access to the courts, but navigating a federal lawsuit as a pro se plaintiff is very difficult.
To say the least, right? Oh, that's great that you brought up the new law, because that's one I've never heard of before. So I should have. Thank you very much for that. And Wasim, you're next. Can you trust the sites out there that say you have free use?
I'm going to talk about two sites in particular, but there are several out there. But the big ones, and they are the big ones because they've been talked about in Pointer of all things. And WordPress has teamed up with this website, Unsplash. There's another one called Pexels, which I'm going to read off Pexels' license page right now. It says, legal simplicity. All photos and videos on Pexels can be downloaded and used for free. Attribution is not required. Giving credit to the photographer or Pexels is not necessary, but always appreciated. You can modify photos and videos and be creative and edit them as you like. If that sounds like a disaster, it's because it is. I actually, myself and other journalism educators, wrote a sharp counterpoint in our various publications. I wrote one in F-Stoppers, and Mark Johnson from UGA, visual educator down there, wrote one in his blog, and it got some traction about how horrible it was for Pointer to recommend that journalists use Unsplash to fill out their website with photos, because posts with art get more attention. And the reason this is so dangerous is anybody can upload a photo to Pexels or Unsplash. I can take a photo that Dane Taylor over there shot for the newspaper and put it on Unsplash and say that it's mine. And someone can download it and they'll say, well, oh, look, Pexels said it was free to use and do whatever. And they can run it all in their publication, and there's going to be no indication that I was not the original photographer for that image. You open yourself up to so much legal complication if you really believe that these websites are okay to use for imagery. I think it's, primarily probably not visually driven people who are making the decisions to, oh, we're gonna put Unsplash and tie it into WordPress and make it part of the content management system. That's a terrible idea. And I would caution any journalists to stay far away from any site that offers you photos for free, without any license, without any attribution, because at the end of the day, you have no idea where those photos have come from, whether you have the rights to use it, and if you're opening up your organization or yourself to some sort of lawsuit, basically.
Wasim, that is so true. And I think that, for anything, that when you're going online, there's so much information out there that you think is actually true, and so many times you find out it's not. So thank you very much for that answer. And Jesse, you're going to go next. Legally, is there any difference between when a news outlet website uses one of my photos on the site, or whether the site only embeds a social media post that contains my photo?
Thanks, Diana. That is an excellent question. And there is an important difference in those two sort of factual scenarios that you pointed out. And I don't want to get too deep in the weeds on the law here for this audience, but there is an interesting legal sort of split of opinion on this particular point. So at a basic level, when a website displays a photo, there are sort of two general ways that photograph is displayed on the website. The one way that we might all be familiar with, and that sort of fits your traditional idea of viewing a photograph on a website, is that the website hosts the photograph. And what that means is that the website, when the website hosts the image, the website essentially has code that directs the website to draw the image from that company that owns the website, from the server of that company, and then takes that photo from the company server and makes it available for the user on the website. That's hosting the photo. There's another sort of key different way for a photograph to be visible on a website, and that's called embedding. The key difference there is that the photograph is not on the company's website. So if I'm a company and I embed a photo, typically you'd think of inline embedding, which is essentially, you'll see on a website that it's not just sort of the image. Typically a Twitter or an Instagram sort of, it's almost like a little piece of Twitter or Instagram is visible on this other website. And when you can go and click links that send you to the Twitter, Instagram page, or lots of other sites allow for embedding, like YouTube. And the key difference there is that if I'm the website and I'm embedding a photograph or video, the photo or video is not hosted on my server. And years ago, there in a case called Perfect 10, the Ninth Circuit Court of Appeals, which is the federal appellate court that covers the Western states, including California, established something called the server test. And basically, for purposes of copyright infringement, one of the key elements is that the photograph has to be displayed in order to satisfy the elements of the photo infringement claim, copyright infringement claim. And according to this test, if the photograph isn't on your server, so if you're in the embedding situation where you're the website and you're just drawing it from another company's server, then that display element is not satisfied because you're really not displaying the photograph. You're sort of pointing to it as it exists on another website without actually hosting it on your own. And that test has been sort of embraced by lots of media companies and was thought for a long time to be sort of what the law was. But this interesting split that I mentioned earlier comes from federal courts, really in New York, that are starting to express hesitation towards the server test, questioning the underlying reasoning of the test, disagreeing that the Ninth Circuit opinion, which is from a different federal court, would apply in New York, which is governed by a different sort of federal appellate court. And so the short answer is legally there is an important difference. It may be the takeaway now is that there is less of a difference. There was a difference and the law recognizes that difference, but particularly if you're in New York, there is a growing appetite for courts to really not make a distinction between those 2 points. So I think the takeaway is that if the photograph from another website is visible on your website, you should think seriously about whether you have any defenses to that, because it may be that your defense that I wasn't displaying it on my site, I was merely embedding it from a different site, may not fly.
Well, thank you very much for that answer, Jesse. That definitely is an interesting topic about the embedding and not embedding. So Christina, you're next. If I am a full-time employee, do I own the copyright to my work? Very important question.
So this is a pretty short answer. For the most part, no. I'm pretty sure under the current Copyright Act, and if Jesse or Craig want to chime in after, but I'm pretty sure that under the current Copyright Act, the publishing rights and copyright of any work for hire belong to the employer. So if you were hired specifically to create that image, if it was taken during work hours, or if the work was done to serve the company in some way, you don't own the rights to that image. Unless it's maybe clearly stated in your contract that you would retain the rights in some way or still be able to post them. For the most part, any work you do employee or work you do for hire as a freelancer is going to be owned by the company or the business that you're shooting for. So I would say if you want to retain the rights to your image, note that in a contract with the company if that's something they would allow.
Well, Jesse or Craig, do either of you have anything to add to that?
She's got it down pretty good. The only little caveat is that work for hire, you need to be an employee. So if you're an independent contractor or freelancer, not actually as a W-2 employee, it wouldn't be covered under work for hire. You need to have an assignment agreement with your contracting party in order for them to own the rights.
Well, Craig, while I've already got you here, I'll ask you the next question. What penalty is there for a publication if it uses an image without permission?
Well, there's three penalties for infringement under the Copyright Act. One is an injunction to prevent them from using the work. The other is damages, and the third is legal fees. Now, in addressing damages, this is the most important distinction and probably the most important thing for the audience to consider. There's an enormous difference between a timely registered copyright and an untimely registered copyright. And in this context, timely is going to be one of two things: either that you registered it before it was infringed upon, or better yet, that you registered it within 90 days of its first publication. Because the statute provides that if you register your work within 90 days of its first publication, that the Copyright Office will backdate effective date of your registration to the date of first publication, meaning everything will have been infringed after your registration. Why is this so important? If your work is infringed upon and it was registered before the infringement, you are entitled to statutory damages, which is a range of damages from $750 to $30,000 for non-willful per work, or up to $150,000 for willful copyright infringement. You're also entitled to your legal fees and costs for bringing the action. If the copyright action is for an untimely registered work, then you don't be entitled to actual damages. Now, actual damages are much more difficult to quantify. Essentially, they would equate to your licensing fee that you would have charged and any profits that the infringer may have earned from the usage of your work. They're difficult to quantify, and the absence of attorney fees makes it very difficult for you to find someone who will bring that action for you, because essentially if all that is at stake is the licensing fee, and that is not something that is recoverable without the necessity of litigation, you are capped at such a low number, you may find it difficult for someone to be willing to bring that for you. So the key here is that you need to register your works within 90 days of first publication. First publication, let's make it simple. Any effort that you make to sell or publish or display the work outside of your immediate family, for example. So if you put it on, if you show it to your friends and family, that's not publication. If you put it on Instagram, if you put it on your website for sale, if you sell it to a paper that puts it in a newspaper story, that's publication. So look at that date. It's a critical date, 90 days from date of first publication, and try to get all of your works registered by that date.
Great. Well, thank you very much. I chose both sides of the story, what you can end up having to pay and what you can end up having to earn, possibly if you win your case. So Wasim, you're next. What are some of the situations where photos you take can be used without permission?
So in some cases, if you're doing something in the case of commentary, like you're writing an opinion piece about the photo, that could be a case where, that, and again, it's that whole looking at each individual circumstances, as the lawyers in the room have talked about, and deciding whether that warrants that, because sometimes it's very tangential. But if I'm writing a piece talking, like, so I'll give you an example that I've done from F-Stoppers. I wrote a commentary, and it's funny because I've written this article several times now. The headline of the article was photojournalism is only for white men, and it was a commentary on the photo of James Comey during his testimony, where you see all of the photographers and one photographer got on the other side and got a picture of the whole room of photographers taking a picture of him. And I did a count, and it was, I think there was one woman and one minority in the entire group. And so that spurred that whole article. And since I was writing commentary on that photo, you know, that was okay, or at least the New York Times didn't come for me after that. I did it again, actually, with Brett Kavanaugh, when pretty much the same exact photo happened. And actually, in kind of a tongue-in-cheek kind of thing, I used the exact same words from the first article, with the editors knowing I was doing this. Same headline, just put a still in front of it and used the photo that ran a Brett Kavanaugh that way. So, you know, in that case, that was specifically commentary about those photos, and that would be a circumstance where you your photo could be used in that regard.
Well, great answer there. And actually, Jesse, I'm going to ask you another question, because I think if we can get it in before the Q&As, it's a good one. And that is, what about if you published a photo and had permission, but the time passed is so long that you no longer have access to proving that?
So it's a great question. I mean, I think that you know, in all of this is you would consult a lawyer who would advise you on your rights. There are varying sort of degrees of evidence that you might need to come forward with to demonstrate your ownership. There are also various, you know, statutes of limitation that apply that may preclude your ability to file a lawsuit for a photo. And interestingly, you know, what if you published your question was, I think you said, what if you published a photo and the time passed and you no longer have access to proving that? I mean, it's just so many different, there's so many different ways to address that, because it's what if you're a newspaper and you published the photo a long time ago? What if you're a photographer and you published the photo by displaying it, or you registered it, or maybe there was something wrong with the registration? So I think it's a little bit hard to answer that in the abstract. I think the general guidance would be to just seek out a lawyer who advise you on your options and sort of the degree to which you would have an uphill battle to prove an infringement claim if you're the photographer, or to defend against an infringement claim if you're the publication.
Okay, Jesse, thank you very much for that. And Craig, I'm actually going to give you a little bit more information about, because this is a real story, so you can also chime in there. A photo that was used many years ago in a publication, and they no longer had proof that, but they always got permission. I mean, whenever they did. So now they're in this situation where they can't prove it because it's so long before. How would you respond to that question?
Well, I mean, what we have here is a contested issue of fact. One person is saying, I had permission. The other person is, at this point, I guess, saying, you didn't have permission. And the resolution of that, sadly, is that we'd have to take that question all the way to a jury. And that would be a jury question, and they'd have to answer, who do they believe more? And they take into account all the circumstances for the publication. What was the connection between the photographer rights holder and the publication? Why would they have given permission? I would think the takeaway lesson here is one that I would recommend to everyone, which is try to get this stuff in writing. Today, you know, with email being what it is, there really isn't a reason not to have an email or some sort of writing memorializing what exactly the permission was. Now, what we're talking about with permission, we're talking about a grant. You're granting them the right to use your image for whatever purpose, or the publication is asking for permission. You want to make sure that those match as well, because what we see quite often is situated purposes, and then lo and behold, the publication uses it for the exact opposite purposes. And if that's in writing, it's easy for us to prove. If it's not in writing, it becomes a he said, she said problem, which are difficult to resolve quickly. And that's what everybody would like. They'd like something to resolve quickly. Those don't resolve quickly. Those go all the way, if necessary, to a trial.
Okay, well, thank you very much. And Brendan, I think we've got a lot of questions going on here, so let's sort of move on to the Q&A part of this.
Hi, just to clarify, are you all talking about federal law, or are you talking more specifically to New York law?
When we're talking about copyright law, copyright has exclusive jurisdiction to the federal courts. So the only place you can bring it is in federal court. Now, that said, as Jesse mentioned, there is more than one federal court. We have 11 circuits plus a DC circuit. So there's 12 circuits. And within those circuits, there are a number of district courts. So in New York, for example, you have 4 districts, the Eastern, Southern, Northern, Western districts. And in each of those districts, there are different courthouses. And then there are different judges. So you have a whole host of law. The way the system is organized, the judges, the district court judges, the trial judges have to follow whatever case law exists from their circuit that they sit in. That's binding authority on them, and they're obligated to enforce it. However, if there isn't a case on point at the circuit level, they're free to render any decision that's not inconsistent with whatever comes tangentially close to it. So that's how it's set up. I guess the answer to your question would be federal law as it's applied in New York.
Hi, I am a director of photography for a national publication. Therefore, I get images from many sources who are not local. And I noticed that many times people hand photos. I ask them if they have any photos that we can run, and they submit photos. And it's obvious to me that it's either a professional photo or it's not. I'm not sure if the person owns the rights. So I follow up, but my question is about: would it be a defense to say that the person willingly gave me the photo to be published, even though they might not understand the ownership of the image?
I mean, that part, I might have one of the lawyers answer if that would be as a defense. But I know a lot of times when we get handout photos, I mean, if the person who's sending it to you says they have the rights to the photo, I would ask them if they know who took the photo and try to contact that person directly to make sure they actually gave the allowance to publish the photo. And like I said, I always check the metadata to see if there's any copyright data embedded in the image, or the reverse image search, just to see if that picture is posted anywhere else with copyright information.
Yeah.
I'm not sure if having it sent to you by a third party could be a defense in a copyright case.
Yeah, I'm saying I asked them if they have the right to publish the photos, and they say yes. But I'm taking their word at that point. I have no legal proof that they do have the rights. So having that in writing, them saying yes, I grant you permission to publish this photo because I have the rights, is that enough? I guess is my question. It's a little complicated.
Craig, would you have an answer for that? Would that be a defense to using the photo in publication?
Yes and no. Yes, it's a defense. What the claim would be is that they are claiming to be an innocent infringer. So if the photo belongs to somebody other than the person who provided it to you, and you published it unknowingly, but with a reason to believe that you had permission from the rights holder, then you'd be able to assert an innocent infringer defense. And that would cap the statutory award at $200. It's not a perfect defense. It does not work against an actual damage claim. And it doesn't mean you can't be sued. And it doesn't mean you won't have to pay the $200. But it is the closest defense to what this fact pattern is talking about.
Well, thank you, Craig, for that. And I'm going to go to Wasim. And Brendan, could you unmute Darius so he can ask his question?
I have a follow-up question to one of your panelists about the ownership of my photos and video. If I'm working for a company that doesn't really require that I post on social media, but I'm encouraged, but I own my social media site and control the content that goes on there on and off the clock. If I'm working on a story, I'll post about that story, post video and photos. I think because I'm on the clock, my company has automatic permission to use my stuff. As a matter of fact, I also call them and tell them to put it on their website, because a lot of times they'll overlook my social media stuff. But when I have permission to, when I have the right to hold that ownership and give permission or deny permission by those seeking permission to use my photos and video, if that makes sense.
Wasim, did you get all that?
Okay, I'm gonna try to break this down. So what you're saying is you post photos of stuff you're doing for work on the clock, on your own personal social media,
Right.
not on the company's social media.
Correct.
But you're on work time. Are you using company gear?
No, actually, I use my own personal gear to do my work, because my company gear sucks. So everything's on my own personal gear. Yep.
So I'm gonna probably toss this to the lawyers, given that social media was in its infancy when I was working at the newspapers. So you know, on your own personal social media, not with company gear, you know, does it fall under the you know, being a full-time employee, you work for the newspaper or whatever, you take the photo and that's their property? So I think I'm gonna punt that one to the lawyers, actually.
All right. Is part of your job description to take photographs?
No.
So if we were looking at a classic work for hire definition, you weren't hired to take these photographs. They wouldn't transfer ownership automatically to the company by virtue of you just being an employee, unless it's part of your job. The fact that you put them on your social media is not really a relevant factor. You would own the photographs if it's not part of your job, if it wasn't part of your work description, and they wouldn't have any right to use them at all unless you gave them that right.
Okay, thank you very much for that. And we're going to go to William next. William.
Hi there. I film horses, and many times in the arena there will be music accompanying the horse's performance. And if I'm planning to sell the video, even to a private person who maybe owns the horse, do I have an issue with fair use concerning the audio portion? I use a boom mic, so I'm picking up the music from the house speakers.
Okay, so I'm going to let one of you choose to answer that question. Is that one you can answer, Chrissy?
I've never really dealt too much with the video and audio, but I feel like if it was just something that was picked up in the background, it's not what the focus of your video or audio is on. If you're filming horses, that would be the focus. So I feel like any background noise or anything picked up, I feel like that would be okay. But maybe from a law standpoint, one of the lawyers could answer, but I think video wise, it would be okay, because if you're shooting horses, you're going to pick up other action in the background, and that's okay to use.
Craig, do you have an answer to add to that? Because that is kind of an important question. You know, when you're in that situation, it doesn't have to be just with horses. Sometimes there's just background music.
Right. So a perfect answer, I don't have a perfect answer. I have a knee-jerk answer. You know, there have been claims made in other contexts where images in the background of a movie were picked up and recognizable, and claims were made by the rights holders to those images. You know, photograph that picks up another photograph. The fair use test is going to come in here, and we're going to look at it. Does your work replace or take away the market for that song? And it doesn't sound like it does. The purpose and nature of your work has nothing to do with the music that you incidentally picked up in the background. So
That is correct.
my feeling would be that you would have a very strong fair use defense, and most people wouldn't bother like bringing that claim.
Well, YouTube and Facebook both do, believe it or not. If I try to post a video of a horse performing and there's music in the background, even taken with from my boom, they're just really hypersensitive and they'll cut me off, or they'll not allow that video to be monetized on YouTube, for instance, or a live stream for Facebook will be stopped if music is a part of a horse's performance. Just want to let you know that part.
Yeah, well, keep in mind that the outlets, the media outlets that are available can have their own rules. They don't have to actually follow anybody else's. They're their own arbiter of what is and is not appropriate for their network.
Sure.
Your question, I guess, is, legally, am I okay? On YouTube, you may not be okay, but in a courtroom, you'd be fine.
I appreciate that.
One of the things I want to bring up too is that when you do freestyle, musical freestyle in dressage, there's a combination of different musics and very much public. So I could see you having a lot of difficulty with that.
Yeah, Diana, I met you about 3 years ago, I think, at the AHP conference.
Karen has a question that she wanted to ask for a while.
Excuse me, thank you. I work in sound. I work in public radio and in podcasting. So I'm curious about fair use applications, particularly because, and Craig, please correct me, you said something about there's a distinction between work for hire and freelance. I may be wrong about that. But my question here then is all of the raw material, my understanding was the raw material, including all the audio of any kind, whether it's interviews, whether it's music, whether it's and non-audio, the scripts, the iterations, my notes, all of that stuff. I was under the impression I owned that. I'm currently faced with a contract that claims the person who's the entity that's hiring me owns the raw material. Is that a distinction between freelance and work for hire in this case?
All right, so I'm going to walk away from the definition of freelancer for a second, and I'm going to plug in a different definition and just use the IRS one. Do you get a W-2?
Yes, because it's more than $600, yes.
Right, so you're an employee, right? You're not an independent contractor.
Except the contract specifies I'm an independent contractor.
Then they can't be paying you by W-2. That's a different issue altogether, right? But this is the distinction here.
Okay.
Work for hire covers employees. It does not cover independent contractors. In order for an independent contractor to assign their rights to their contracting employer, if we want to call them the employer, it would have to be in the agreement. Whereas work for hire is a creature of law. You don't need to have a rights assignment because the rights belong immediately on creation of the work to the employer.
That's the final product, correct? That doesn't imply the iterations.
All rights. All rights to all things created in the scope of the employment would belong instantly to the employer. Now, that does not mean you could not have an agreement in writing with your employer that says otherwise. But the starting point definition is if you're an employee and you are working in the scope of your employment and you create a work, it belongs to your employer.
So we have time for one more question. We're going to go to Cecilia Dowd.
Thank you all for being here. So my question is this, and this hasn't happened, but what if, often the police will put something out, right? A photo of a missing person, or perhaps a photo of somebody running from a crime scene and they're looking for the suspect. I'm curious, it's a little similar to Alfredo, but I think it goes a step further. Let's say, every news outlet blasts that photo on TV and online. And then, this person comes forward and wants to sue everybody because they're like, well, the police never should have put it out. I would assume, I don't want to blame the police. Like, let's say a municipality put it out, or some law enforcement agency. would they'd be on the hook, right? Or would we? Because we don't question typically a handout photo from an official agency.
I guess that's going to be for you, Craig.
Okay. So let me walk through this with you. We get a photograph from the police, and the police are looking for someone, and we publish that photograph. I can't.
Yes, yes. For example, missing people, right? They put photos out all the time, and we don't. I mean, my outlet is super strict. So whenever I get photos from people, I have to get consent language, etc. But if you get something from police, you automatically can use. You know, you don't have to get consent because the police are giving it to you. But what if, you know, let's say they had put out a photo of a missing person and someone said, well, I took this photo and they didn't have the right to do this. And, you know, or something else, like somebody had taken a photo of a suspect at a crime scene and it went out as a so-called like kind of a handout. Would we be on the hook for that as
Right,
reporters and media outlets? Yeah.
So your example on the missing person, we'll make this one the example. We'll use that one. And then I'll tell you a quick aside. On a missing person, where everybody's looking for that person, the usage of that photo would be considered fair. Which I don't think anybody would challenge that. Now that means that the police who may have appropriated that photo without the permission of the author, they wouldn't be held liable because they're only using it to find this person, and everybody else in that similarly situated would also be insulated under a fair use. But I said I'd have a quick aside. So we have a case pending right now where there's a photograph that was part of a defamation lawsuit. And it's our client's photograph, and it's part of that lawsuit. And somebody's now reporting on that lawsuit using that photograph. And as I said, we regularly as a group debate these type of usages, and we try to figure out, is that fair or not? Is the photo a necessary element of the story? Now, in your example, you couldn't put a story out about a missing person without the photo if you're trying to find them. But in my case, it's a gratuitous photo that wasn't really necessary for them to tell a story about this defamation case. So you can see just in those two situations, and I didn't go into a lot of detail, that there's so much nuance that goes into some of these decisions. And it's really hard to have like a one size fits all cheat sheet on it. I would suggest that, you know, the best advice I could give a publisher who's concerned about fair use is to ask a lawyer before you publish it. And it's really more so because you could then point to your efforts to make that determination before it became an issue. And that's very strong evidence in your favor if it ever got brought up in a lawsuit.
And when you say point to our efforts, so if I went to my company lawyer, should I have that in writing? Should it not be a phone call? Should it actually be an email to the lawyer so that I have that email?
Send an email off to whoever counsel is and say, you know, we're going to publish this photograph. We don't know its origin, but our usage is to assist the police in trying to find a missing person. Is your opinion that that would be fair? You have it in your file, but it's very useful because oftentimes what I complain about when people raise the defense of fair use is, well, when did you come up with that? Before you got sued or after you got sued? Because if you came up with it after you got sued, then you may be right, but it's accidental. You know, that's just creative lawyering at that point. You didn't know when you made the decision to publish it. And isn't that the most important time to know? So I think that's very important. I've used it when people have not done that. And I would suggest that, you know, it's not a hard thing to do, especially if you have in-house counsel, to get a quick knee jerk on it. You know, what do you think? Like I just
Thank
did.
you.
What do you think? You know,
Thank you.
trying to find a missing person, publish it.
Yeah.
Thank you.
Well, thank you. Thank you, everybody.
Yeah.
Thank you, Craig.
Thank you, Craig. Thank you, Diana, for being a wonderful moderator tonight. Thank you, Wasim, for being here. Thanks to Jesse, who had to go. And thanks to Chrissy. This was a wonderful event. I appreciate everybody who asked their questions. I hope that you learned something tonight, and maybe this will save you a lot of trouble in the future. So we are the Press Club of Long Island, and we are a professional chapter of the Society of Professional Journalists. There are also student chapters, and some of you, I hope, visited us from some of our student chapters at Hofstra University, Stony Brook University, and elsewhere around the country. You could find out more about PCLI at pcli.org. We have a post up there that has biographical information on all of tonight's panelists. If you want to join SPJ, that's spj.org. You can follow us on Facebook, Press Club of Long Island, follow us on Twitter at PCLI. And if you want to email us, it's pressclubofli@gmail.com. I want to also let you know that we have our annual awards dinner and Hall of Fame induction coming up at the Melville Marriott on June 2nd. We hope to see you there. Please keep in touch with us. We love hearing from you. If you have any ideas for future events like this that you think will be beneficial to journalists, please reach out and let us know. We're always looking for new members, new people to serve on committees, and just to get your feedback and know if we're doing a good job or not. Thanks again, everybody, for being here.
Thank you.
Thank you.
Thanks, everyone. Thanks, panelists, and thanks those who came in and asked their questions and watched.